Hi, everyone. My name is Sabrina Damast, and this is my amazing colleague, Eric Lee. We recently co-authored an article for the AILA Law Journal on the Doctrine of Consular Nonreviewability. It's a long title for a very old, complicated, and annoying doctrine. And so we wanted to record this for you so that you would have a little background on what the doctrine is, why it's important to immigration lawyers, and what the state of the doctrine is in current federal court litigation. So with that, Eric, can you, in a nutshell, just sort of describe for us what the doctrine stands for and how it impacts our practice as immigration lawyers?
So the doctrine essentially says that if your visa is denied, you do not have the right to go to court to challenge the denial unless, under very certain specific limited conditions, you are the spouse or immediate family member of someone whose visa was denied. And if the government can't show that its decision was facially legitimate and bona fide. There's a lot of cases out there, including the one that we focus our law review article on, which describes a little bit of what that phrase facially legitimate and bona fide means. But it's a really important area of the law for immigration lawyers and for everybody, because it's a state of exception, which says that you don't have the right to your day in court and you don't have the right to due process, except under these narrow conditions, which just got a little less narrow.
So are you saying to me, for example, if my client goes to a consular interview and he's never been arrested for anything in his life, and they make a finding that he's been convicted of a crime involving moral turpitude, that I can't go to federal court and challenge that, or at least presumptively, unless I meet one of these exceptional conditions, that my client is out of luck in getting himself admitted back to the US in a visa status?
Yeah, that's exactly right. It's a area, it is, and it's completely unfair. It's resulted in countless families getting split up, mothers and fathers and husbands and wives being banned for life from entering the United States. And worse than that, as you've just said, in most cases, the courts say that you don't even have the right to bring a lawsuit in federal court to challenge those denials. It's a remarkably exceptional, in the worst sense of the term, extra constitutional area of the law.
Okay, so I understand now why this is a dramatic doctrine, which is impactful on anybody who's ever touched a single consular processing case of any kind, right? Immigrant visa, non-immigrant visa, anything. So you recently got an amazing decision out of the Ninth Circuit called Munoz versus Department of State. Tell us a little bit about Mr. Munoz, what he was found inadmissible for, and why you were able to shove a wedge in that door into federal court for a consular denial.
So this was a case with a U.S. citizen wife and a Salvadoran husband. The husband had been living in the United States for many years, no criminal record, as you said, not in the United States, not in El Salvador. And nevertheless, he was, after applying for his green card and everything was going smoothly, he went to El Salvador as the last stage in his green card process, thinking that he was going to be back after a long weekend or after a couple of weeks, and he hasn't been back. And that was 7 years ago. That's because...
What was he found inadmissible for by the consulate?
So he was found inadmissible under a statute that says that you can't enter the United States if you're going to engage in any other unlawful activity.
This is one of those 212A3 things, right? It's kind of grouped together with terrorism and security grounds, right?
It is, but it's a catch-all provision which says that even if you're going to enter the US for a totally legal reason, even if you might incidentally engage in some illegal activity, other unlawful activity, which could be jaywalking, for all we know, that you can't enter. And that's what they told the husband in this case, even though he asked for the exact reason why. The State Department continued to refuse to tell him. It was only after we beat a motion to dismiss in federal court that they said that they think that he's a gang member. And the Ninth Circuit said that that wasn't good enough, that violated the due process rights of his U.S. citizen spouse.
So was it the fact that they would only give you a vague answer that was a violation of due process, or was it the fact that it took them years of well into federal litigation that bothered the court, right? That they didn't even cough up that very minimal answer until 3 years into your process.
Yeah, it's both. And while this is an important decision, and while many practitioners know they get that one sentence consular visa denial that just cites the statute, it's a narrow ruling in the sense that they said that if they provide the reason immediately, then you may not have recourse. You still are not allowed to go to court. Nevertheless, it is a very important decision for the reason that you said it, and the government has to now, after this decision, provide the factual reason for the denial really quickly after the denial, so that the person and their family has the due process right to challenge the basis of it and submit evidence that the decision may have been wrong, so that the State Department can make an informed decision.
All right. Well, that is fabulous, right? It's a great thought that at the very least you have to provide sufficient notice to try to give the person the opportunity to rebut the negative finding. And it's fantastic that you now have that enshrined in a published circuit court decision. Congratulations to you on that. To all of our AILA colleagues, we invite you to read the article. The article, as you will be able to see, was completed before the published decision in Munoz came out. So there's a lot about the trial court proceedings and nothing in there about the actual Ninth Circuit decision. So when you're done, go read the Ninth Circuit decision too. And if you are thinking about litigating these cases, Munoz is a great place to start, and feel free to email us because we're really nerdy and we're really enjoying this and we want to help other people dig into it too. All right. Thank you all for watching this video, and please read the most recent edition of the AILA Law Journal.